Hello, everybody out there in Radioland. This is Glenn Winningham, House of Fern, and do you know who you are? And you are listening to These Changing Times radio station, and today we're talking about common law. You can, for anybody that's interested, I've got a website. It's www.sovereigntyinternational.info, all one word. I've also got some groups where you can get some documents and things like that I've done or that I've gotten a hold of. One of the groups is on These Changing Times radio website under the groups link, and it's called sovereigntyinternational.info. There's a couple of groups also that I have at Yahoo and Google, one each at Yahoo and Google, and those ones are called Administrating Your Public Servants. And you can go there and find out things there as well. They're private groups. You have to go there and request to join. Anyways, and I've got some videos that are available. When you go to my website, sovereigntyinternational.info, you can order some videos there if you're interested of private information shares that I've done, and I'm available for private information shares as well. Anyways, so what we're doing today is we're talking about common law, and you have to understand that common law comes from we the people. It is the unwritten law, the decision of courts. Now, when I say it's the decision of courts, it's the decision of common law courts, and you have to understand how a common law court works. It's not statutory law; it's the unwritten law, and that's what it's called. It's called the unwritten law, and we'll go through what the courts are saying. But it's the law of the people. It's our law, and anything else doesn't mean anything to us. We all have to understand that. This is what the courts are saying. Anyways, so there's a common law of England. There's also a common law of Europe. There's a common law of Germany. There's a common law of Denmark. There's an international common law, and there's a common law of Russia even. There's a common law all over the place. Common law is everywhere, and we have to understand that. Once we understand that, then we can use that to our advantage. But there's a law of nature, okay? The law of nature is natural law. Common law is natural law. Common law is the law of the land. And so when you hear something that talks about the law of the land, they're talking about common law is what they're talking about. And here's a court case, U.S. versus Morris. 125 Federal Reports, page 322, quote, every citizen and freeman is endowed with certain rights and privileges to enjoy which no written law or statute is required. These are fundamental or natural rights recognized among all free people, unquote. And so, again, that is U.S. versus Morris, found at book 125, Federal Reports, page 322. So, our rights are not defined. We have all rights. We are the king or the queen. All of our rights are we have every right, and it's not defined. And so it's anything. Okay, I mean you have the right to everything. You have to understand that, and most people think that there's some Bill of Rights defines our rights. Well, no, I'm sorry, it doesn't. It defines the rights of persons, and my rights are not defined. And the Bill of Rights, all they do in the U.S. is bring in some common law rights. But the bottom line is that my rights are undefined, and that's what this court case is saying. Now, this is a case called Hale versus Henkel, found at 201 U.S. 43. This is U.S. Supreme Court. And it says, quote, the individual may stand upon his constitutional rights as a citizen. He is entitled to carry on his private business in his own way. His power to contract is unlimited. He owes no duty to the state or to his neighbors to divulge his business or to open his doors to an investigation so far as it may tend to incriminate him. He owes no such duty to the state since he receives nothing therefrom beyond the protection of his life, liberty, and property. His rights are such as existed by the law of the land long antecedent to the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are a refusal to incriminate himself and the immunity of himself and his property from arrest or seizure except under a judicial power warrant, a warrant of the law. He owes nothing to the public so long as he does not trespass upon their rights, unquote. Now, let's look at this again and analyze this a little bit. One of the things he says, first of all, it says the individual may stand upon his constitutional rights as a citizen. Well, the word citizen is capitalized, okay? And that is like in the Bible, okay? God's name is capitalized. The king over in Europe, the king is capitalized, okay? So you got to understand, this is talking about a common law citizen. Anyways, he owes no such duty to the state since he receives nothing therefrom. In other words, if you get anything from the government, then that's the contract, and you just give up your sovereignty, okay? You cannot get anything from the government, okay? I'm the king. I don't need anything from the government. I don't want anything from the government. And he owes no such duty to the state since he receives nothing therefrom beyond the protection of his life, liberty, and property. Now, the state has a duty to provide him with protection because that is why we set up governments in the first place, okay? And then it goes on and says, his rights are such as existed by the law of the land long antecedent to the organization of the state. Well, law of the land is talking about common law again. And so his rights are such as existed by the law of the land long antecedent to the organization of the state. Antecedent means before. And so, in other words, my rights existed by the law of the land before the state was even here. And so my rights supersede anything the state can do. There's nothing. And again, it goes back to that case, Penhallow versus Doan's Administrators. And there is nothing the government can do to affect the rights of the people. Absolutely nothing. If you know who you are, there is nothing they can do to affect your rights. So his rights are such as existed by the law of the land long antecedent to the organization of the state and can only be taken from him by due process of law. And that means due process of law means a jury of my peers, okay? That does not mean U.S. citizens. That means state citizens and a jury of my peers. And first of all, they don't have the authority to convene a jury of my peers. And so that'll stop everything. If they try to do anything, a state citizen technically could probably commit murder, and there'd be probably nothing they could do. A lot of it depends on how much you know about the law and how much you're willing to push it. But I have heard of people who were state citizens and they were in a jury trial. And so what happened was they started calling a jury, and one of the things you can do is you can question the jurors. And so all he did is he went up to the jury and he said, "Are you a U.S. citizen?" And they said, "Yes." And he says, "I would disqualify him." And then he says to the next one, "Are you a U.S. citizen?" And they said, "Yes." And he says, "I disqualify him." And so then the Crown prosecutor came up and said, "Well, hold it now. Are you going to do that to all of them?" And he said, "Yes." And so then they said, they got the county sheriff in, and they said to the county sheriff, they said, "Well, we need you to convene a jury of state citizens." And the county sheriff says, "Okay, I'll see what I can do." And 2 weeks later, the county sheriff came back and said, "I can't convene a jury of state citizens." And they dismissed the case. And so that's the point, okay? They don't have authority to convene a jury of state citizens, okay? Only we, the people, have the right and the authority to do that. We, the people, are judicial power citizens, and there's a court case that talks about that. We, the people, are superior. We're the king, okay? Only we, the people, have the power to do that. Quote, this law of nature being coeval with mankind as dictated by God himself is of course superior in obligation to any other. It is binding over all the globe in all countries and at all times. No human laws are of any validity if contrary to this, and such of them as are valid derive all of their force and all of their authority immediately or immediately from this original, unquote. And that's taken from Blackstone's Commentaries on the Laws of England. And Blackstone, Sir William Blackstone, this book was this is actually a 4-volume set, written between 1765 and 1769. William Blackstone was an English jurist who wrote these books, and they're very good, and they explain the law very well. The guy was, he was brilliant in my opinion, and so at any rate, that is taken from there. And let's look at that a little bit, okay? It says, this law of nature being coeval with mankind and dictated by God himself, okay? In other words, God decides what the law of nature is, and is, of course, superior in obligation to any other. It is binding over all the globe and all countries. It's effective. Again, this is common law, okay? It's everywhere, and I don't care what country they're in. Common law is there. And at all times, no human laws are of any validity if contrary to this. No human laws, I just cannot say it enough. Their laws mean absolutely nothing to me if they're not in accordance with the law of nature. And that's common law, and that's my law. And such of them as are valid derive all their force and all their authority immediately or immediately from this original. And quite frankly, the only ones that can come close to being valid are things like murder, assault, the common law offenses. And so you have to understand that that's the only ones that could, let me stress could, because if you read their definitions apply to fictitious entities only. And so they could be valid. And we the people, it depends again on how knowledgeable you are about their procedures and all the rest of it, but you might be able to get out of even that. Okay, so, yes, Blackstone was an English jurist. He lived in the mid-1700s or early 1700s. His books were written between 1765 and 1769. He wrote the Blackstone's Commentaries on the Laws of England. Blackstone's a phrase taken from Blackstone's Commentaries on the Laws of England, a phrase about the law of nature and nature's God, was used by Jefferson in the Declaration of Independence. This is where the phrase is. It says, quote, when in the course of human events it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station to which the laws of nature and nature's God entitle them, a decent respect of the opinions of mankind requires that they should declare the causes which impel them to the separation, unquote. And that's the preamble for the U.S. Declaration of Independence. And then it goes on, it says, quote, we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, and among these are the life, liberty, and the pursuit of happiness. That to secure these rights, governments were instituted among men, deriving their just powers from the consent of the governed. That whenever any form of government becomes destructive to these ends, it is the right of the people to alter or abolish it. And I think it actually says it is their duty. And I'm pretty sure it does. I'll have to look at that because I'm pretty sure it says that. Anyways, the bottom line is that Jefferson knew what he was doing when he wrote the Declaration of Independence. It's very good. It goes on to say, quote, but when a long train of abuses and usurpations pursuing invariably the same object evinces a design to reduce them under utter absolute despotism, it is their right, it is their duty to throw off such government and to provide new guards for their future security, unquote. And there's where it says it is their duty. And so, quote, as a general rule, men have the natural right to do anything which their inclinations may suggest, if it be not evil in itself and in no way impairs the rights of others, unquote. And that's found at Henry Newman, 1858, 9C 502. And so, again, that's the law of nature and natural rights. I have all my rights, okay? I can do anything. It's not, they haven't defined my rights, okay? And nobody can define my rights because my rights are unlimited. Quote, all acts of legislature contrary to natural right and justice are void, unquote. And that's Robin versus Hardaway, 1 Jefferson 109, and that's in 1772. And so, again, there is nothing the government can do to affect the people. And you have to understand that, and you have to, because they're bankrupt, and we talk about that in De Jure Government, the Ultimate Solution, because they're bankrupt, they presume certain things. They make laws that really aren't laws, that don't apply to anybody, and if we get ourselves involved in them, they're viewed to be contracts. And they do it all the time. And so the burden's on us to understand the law and to shift the burden back onto them to tell them, where's your authority? You don't have any authority. And once we do that, everything changes. But until we do, they can presume certain things because it's all martial law. And that, all of that is coming from the Vatican. And so the real source of the whole problem is the Vatican, quite frankly. But meanwhile, we have to deal with it, and we have to educate ourselves about the law and how the law works. Quote, among these unalienable rights, as proclaimed in the Declaration of Independence, is the right of men to pursue their happiness, by which is meant the right any lawful business or vocation and any manner not inconsistent with the equal rights of others, which may increase the prosperity or develop their faculties so as to give them their highest enjoyment. It has been well said that the property which every man has is his own labor. As it is the original fountain of all other property, so it is the most sacred and inviolable, unquote. And that's Butchers Union Company versus Crescent City, Colorado, I guess, 111 U.S. 746. That's U.S. Supreme Court, 1883. And so, again, and that's taken directly. It's talking about the pursuit of happiness, okay, which means you're not happy if you can't eat. And so the pursuit of happiness is harmless activities for profit or gain. And they have no right. The right to your labor is not subject to taxation. Matter of fact, that's why the IRS thieves ask for occupation in their tax form, because if you put down that you're a laborer, that's a problem for them. But most people say, well, I'm a domestic engineer, or I'm an aerospace engineer, or I'm something really important. And so you're not a laborer, and now we can tax you. And so it's very important. They know exactly what they're doing. They have lawyers, foreign agents of the Vatican all over the place, and they're laying awake at night coming up with this stuff. And, don't get me going. Anyways, the common law of England consists of 800 years of jury trial decisions. Those are decisions that were made by we the people, okay? And they're found in the Koch reports and the English reports, and there's a bunch of other reports that compile all these reports. But these are all jury trial decisions, and you just don't know the power that we the people have. There's a good example was in 1802, the U.S. Supreme Court convened a jury of citizens and said, tell us the law on this matter. And the reason they did that is because there's a principle called stare decisis, which means once something's been decided, it's been decided for all time. And so what happens is that anytime you get any court case, you go and read these court cases, and there's thousands of them, but they all say, well, in this case, this is what happened, and in this case, this is what happened, and in this case, this is what happened, and all of these cases are similar to this case, so this is my ruling. And so they're always going back to this 800 years of jury trial decisions. They don't have the authority to make law. We, the people, have that authority. So that's the power. That's we the people again. And we're letting a bunch of crooks make decisions for us. We get what we deserve, in my opinion. It is common law juries that make common law and define common law. And if you want to know how a common law jury operates, my presentation on the de jure government, the ultimate solution, will go into that more. But again, it's we the people that decide, okay? And so you got some crook on the bench, some lawyer for the foreign agent of the Vatican that's going around and making legal determinations for you and representing you, and he doesn't have a shred of authority. The first recorded common law jury was found in Wales in 1700 BC, which was brought there by a group of people who came there from the area of the Caucasus Mountains, which is kind of interesting. Sounds like the Ark, Mount Ararat. Wales has always been a bastion of freedom and liberty. Thomas Paine was Welsh, and he wrote a book called Common Sense, which had a great deal of influence on the American Revolution. The Magna Carta was brought about because of the Welsh barons. Wales has always been a major bastion of freedom and liberty. Quote, the common law right to the jury to determine the law as well as the facts remains unimpaired, unquote. And that's State versus Croteau, 2223 Vermont reports, page 14, and that's 1849. And so, again, that is the power of the jury, okay, is the jury can sit there and say, well, this guy is on trial for violating the statute, and this statute is a stupid statute, so we don't care whether he was guilty or not. We're going to call him innocent. We're going to find him innocent because this statute is a stupid statute. So they can judge the law. They can do anything they want. A common law jury can do literally anything they want. Again, that comes down, that's the reason you see these judges going and trying getting rid of these common law juries. Nowadays you hardly ever see a common law jury. Most of them like these six-man juries, those aren't common law juries. When the judge is giving the jury instructions, you see it on Law and Order where they're withholding evidence from the jury and all the rest of that stuff. That's not a common law jury. I don't care if there are 12 people there. It's still not a common law jury. A common law jury runs that courtroom. There are 4 law schools on the planet that teach law, and they are all found in the City of London. And when I'm talking about the City of London, we talk about that more in de jure government, the ultimate solution. No, actually, we talk about it in our presentation on attorneys. The City of London is a 1 square mile area in downtown London that was never conquered by William the Conqueror. And so it is a foreign territory to the rest of England. And if you want to see how foreign it is, watch the convening of the Imperial Parliament. And you'll watch Elizabeth, the Queen, will go to a gate called Temple Bar, which is a gate into the City of London. And she will go there, and the gate will be closed. And this is when the convening of the Imperial Parliament. The Imperial Parliament is in that 1 square mile area. She will beat on that door, and the Lord Mayor of London will be on the other side, and he will open up a little 1 square foot door in there and say to the Queen, what do you want? And she will have to get his permission to come into that foreign territory, and she will have to walk behind him, 2 steps behind him, with her head bowed during the whole trip. And because she is not sovereign in that territory. And that territory is owned and operated by the Vatican, and again, if you want to know about that, it's discussed on the attorney's presentation about the Inns of Court and what all of that stuff is about. There's all other so-called law schools on the planet teach jurisprudence, which is procedure. Has nothing to do with 800 years of jury trial decisions. The people in all countries with the common law of England owe their sovereignty to the common law. Actually, people of all countries are sovereign, but many of them have become are very old and corrupt, and so it becomes very murky. And the judges are all crooks. They're all agents of the Vatican. Don't get me going. But so But the common law of England, we're going to talk about that more here because of the fact that we got lots of court cases that talk about it. But technically, this is everywhere on the planet. It's not just in British common law countries, although the British Commonwealth of Nations consists of like about 150 countries around the world. There's a bunch of them, and all of those have common law. But even Russia, okay, Russia was not part of the Commonwealth countries, and Russia has common law. So anyways, common law was brought into England with the Magna Carta. The commentaries, this is taken from the Commentaries on the Laws of England by Sir Edward Coke. It existed prior to the Magna Carta, and it goes back to the Decalogue, which is the law of Moses. Deca meaning 10, okay, the 10 Commandments. And it probably existed from the beginning of time. The law of England, quote, the law of England is divided into three parts: the common law, which is the most general and ancient law of the realm, statutes or acts of parliament, and particular customs. The common law appeareth in the statute Magna Carta and other ancient statutes, which for the most part are affirmations of the common law, unquote. And that's taken from a set of books called the First Part of the Institutes of the Laws of England by Sir Edward Coke. And Sir Edward Coke lived from 1552 to 1634. So, and what it says is, which for the most part are affirmations of the common law. In other words, when something is affirmed, they're essentially saying they're recognizing something that already exists. And remember that court case, Hale versus Hinkle, that I read at the beginning of this presentation. It talks about that my rights existed by the law of the land long antecedent to the organization of the state. Okay, so it's long before the government was ever established. The law of the land was still there, and my rights come from that. And again, do you know who you are? The Canadian Handbook for Judges says on page 97, quote, Canada is part of what we call the common law world, and England provided the fountain from which the common law emerged. Thousands of English decisions are now by adoption embedded in our jurisprudence, and the decisions of the House of Lords and other English courts will continue, we think, to be cited in our courts and must be given the most careful and respectful consideration as highly persuasive. The Canadian Handbook for Judges says on page 98, quote, the judgments of Australian and New Zealand courts may also have highly persuasive effect, and the similarity not just of the legal system but of conditions in the United States is such that many American decisions may too have a strong persuasive effect, unquote. And so, and this is all talking about common law. In a common law country, the sovereigns are the people. The Magna Carta is called the Great Charter of English Liberty. The Canadian Handbook for Judges cites the Magna Carta as saying on page 77, says, quote, Magna Carta says we will not deny or defer to any man either justice or right, unquote. Well, actually, it doesn't not say exactly that, but and a lot of times these crooks go ahead and deny it or defer it all the time. Anyways, the Queen or President has the oath of office. We, the people, owe no allegiance to the Queen or the President. The Queen or the President owes allegiance to the people. That's why they have the oath of office. Why do we set up the governments in the first place? Remember back in Hale versus Hinkle, okay, it talks about it, that he receives nothing therefrom and beyond the protection of his life, liberty, and property, okay? That's why governments are set up. That's the only reason governments are set up, is protection. It's essentially a protection racket. Anyways, they are supposed to protect us from foreign enemies, and you know, as in national defense, protection from each other, so that we don't kill each other, and to administer disputes in a fair and impartial manner. So if somebody runs over my dog, I can sue them over it. The only legitimate function for government is to protect the rights of the people, and that is it, nothing else. And the hierarchy is that God created, God is King of Kings, and he created we the people. We're the kings, okay? Now that makes sense, okay? God is King of Kings. Well, he's the king of all kings, and we're the kings. And we the people created the government, and the government created corporations. And what we've done is by getting involved in their statutory schemes, we've become involved. We've turned ourselves into a fictitious entity and given them jurisdiction. And that's exactly what's happened, and now we got to undo it. Now, another thing that happens also is because there's so many clueless people out there that go and get themselves involved in this stuff that they can presume that everybody's involved anyways. And so even though we ourselves are not involved in a lot of cases, we have to, the burden is now to the point now that we have to defeat what's going on just to be free. And so, and that's what my procedure does, is it defeats what they're going on, and the proof of that is that they told me that I'm listed as sovereign in their system when they came to visit me about a year and a half ago. It was a year ago last March, so that's, about a year and 4 months. But yes, the FBI and the Texas State Police came to visit me, and they told me 3 times, actually, that I'm listed as sovereign in their system. The third time I was sitting there thinking, okay, you told me that twice before. But anyways, yes. So the point is do you know who you are? And we have to take away their presumptions, put them into estoppel. That's exactly what you're doing. You're putting them into estoppel because now they do not have the presumptions they were taking, and now they have to honor their oath of office, and everything changes. So why is God in the Constitution? You know, it's in the Declaration of Independence. It's in the Canadian Constitution, or the Canadian so-called Constitution, the British North America Bill. Why do they put that in there? They put that in there because if our rights come from God, only God can take them away, not the government. And so that's just another additional thing in there to help protect our rights. And invariably, it's not so much in the States you don't see it happen. They don't dare here. But in Canada, you certainly see the Communist Party once in a while because the people are so clueless. Every once in a while, a new Democratic Party, or I should say the Communist Party, goes and puts out a trial balloon saying they want to remove God from the Constitution. And, quite frankly, that ain't going to happen because the Queen has an oath to God, and she wouldn't allow it. But, they'd probably try some color of law thing. That's usually what they do, is something that really is not law and doesn't mean anything. And really, at the end of the day, if you really know who you are, there's nothing the government can do to affect your rights anyways. But again, it's for the idiots out there that think that they can, because if you think that they can, then they can. They have no right to do anything to us except by common law. Magna Carta, Chapter 29 says no freeman can be taken or imprisoned or seized or exiled or in any way destroyed, nor we go upon him nor send upon him except by the lawful judgment of his peers or by the law of the land. Now, the law of the land's common law, and it's by indictment. And there's a court case in the U.S., for those in the U.S. that talk about that, which brings that in, and that's actually affirmed or reaffirmed in the Article 5 and Amendment. And the phrase law of the land in Chapter 29 means common law. Quote, the words by the law of the land as here used do not mean a statute passed for the purpose of working the wrong. This section was taken with some modifications from the part of the 29th chapter of the Magna Carta, which provided that no freeman should be taken or imprisoned or be seized of his freehold, but by the lawful judgment of his peers or by the law of the land. Lord Coke, in his commentary upon this statute, says that these words by the law of the land mean by the due course and process of law, which he afterwards explains to be by indictment and presentment of good and lawful men where such deeds were done in due manner or by writ original of the common law, unquote. And that's actually a quote that's taken from Coke's Institutes on the Laws of England, Book 2, and this is the whole thing is taken from a quote in a court case, Taylor versus Porter, found at 4 Hill, page 773, and that's a New York Supreme Court case, 1843. The phrase law of the land in Chapter 29 means common law, quote, to be the statutes which would deprive a citizen of the rights of person or property without a regular trial according to the course and usage of common law would not be the law of the land, unquote. And that's a jury decision, Hope versus Henderson, 15 North Carolina reports, page 15, and that's, that's North Carolina. Quote, The Magna Carta is not a unilateral act emanating solely from the spontaneous will of a king, as the charters of the predecessors of John. Neither is it a treaty, for we cannot say it was concluded between two legitimate and independent sovereignties, nor between two nations, nor is it a law. The barons do not appear in it as subjects, for they are freed from their promise of fidelity, and the king brought captive, placed before them, submitted to the conditions which the conquerors imposed upon him. Magna Carta is therefore a contract, but resembles a treaty concluded between two nations, in that one of the parties, in virtue of the law of war, can impose its will upon the other, unquote. And that's Perlman versus Pichet, and Attorney General of Canada, intervenant, reference habeas corpus, for Dominion Law Reports, page 147. So this is a very interesting case because it's a Quebec court case, and people go running around saying that there's no common law in Quebec. Well, BS, there isn't. This one's is talking about habeas corpus. Habeas corpus is a common law writ, and here they're talking about it in a Quebec court case. So there is definitely common law in England, and again, it comes down to there's common law everywhere, and so they just want you to think that all is a civil law, so they can violate your rights, because civil law is a military dictatorship, is what it is. And they want you to think that you're stuck with that, and you have to know how to access common law. Common law is there. All you have to do is plead it. Really, that's all you have to do. But again, you have to understand what's happening and know the law. And so what they essentially did here is they went and stuck a sword to his throat, and they said, "Here, King, we want you to sign this." And the choice was either sign it or they're going to run him through. And so, of course, he signed it. Now, there's another very important principle here, because I've been tempted at times, and I haven't done it. I'm glad I haven't. But I've heard of other people that have. There was a guy by the name of what was his name? He was the Montana Freeman guy out in Montana that the FBI went and besieged his place. I heard that he declared war on the United States, and when you do that, you declare war. I mean, you're declaring war against somebody that's a whole lot bigger than you are and has a whole lot more power. And so they basically abused him, kept him in jail for the rest of his life. I understood that he's died recently, and they didn't treat him very well while he was there. And so I guess the point being is that once, right now, they have an oath of office, then they have a duty to protect our rights. But if we declare war on them, well, all of that's gone. Okay, and you have to understand that, and now the law of war comes into play, and they can force you into their martial law, and you don't have any choice. And it's either you go into their martial law jurisdiction, or we're going to run your butt through. You know, basically, that's the law of war. That's how the law of war works. And so, again, that's probably not a good move. They still have an oath of office. I get really belligerent, and I call them criminals, and I call them all sorts of stuff, but I never declare war on them, although I was tempted there for a while, but I'm not tempted anymore, I got to tell you, because they got a lot more guns than I got, and I would lose. So, I don't want to go there. Quote, "History is clear that the first 10 amendments of the Constitution were adopted to secure certain common law rights of the people against invasion by the federal government," unquote. And that's Bell versus Hood, Book 71, Federal Supplements, page 813, 1947. And that's taken from the U.S. District of Southern California, 1947. Quote, "The law of Congress in respect of those matters do not extend into the territorial limits of the states, but have force only in the District of Columbia and other places which are within the exclusive jurisdiction of the national government." And that's, unquote, and that's Cahay versus United States, 152, U.S. 211, 1894. You got to understand what they're talking about, okay? And if you read in like the IRS, any government federal agency of any kind, that's where their legitimate authority is, okay, is in the District of Columbia and the territories. That is it. They don't have a shred of authority in Delaware or Texas or any of the states. And if they're in there, it's because they've got you in a contract. If they're in there and doing something to you, it's because they've got you in a contract. And that's the only way they have authority. And if you take away their presumptions, and that's why I always send it wherever I go. I send the U.S. Attorney one of my notices. I send the FBI Special Agent in Charge one of my notices. I send the U.S. Marshal in whatever area one of my notices, and I send the Chief Judge of the District Court, United States District Court, in one of my notices. And because I'm telling them that I'm traveling in this area, and you don't have any more authority over me than a Walmart rent-a-cop. And that's one of the things I put in there. And they leave me alone. It's amazing how that works. You got to understand that if you're going to have something come after you, if they say the IRS decides they want to come and kidnap you for one reason or another, okay? Well, the IRS isn't going to get nothing without going through a U.S. attorney, okay? They got to go through a U.S. attorney. They got to go through U.S. Marshals. They got to go through FBI. They got to go through probably the Chief Judge in the U.S. District Court. They got to go through a county sheriff. They probably got to go through a city chief of police. And if you go and notice all these guys and put them on their oath of office, everything changes, okay? There's people I know that have been attacked by the IRS, and there was county sheriffs there was chiefs of police there was U.S. Marshals and FBI. All of those were there. And they don't do anything by themselves. They can't. And you go and notice these government officials, then everything changes. Now all of a sudden they can't do nothing because they got to get these people to cooperate with them, and if these people are going to be perjuring their oath, they're going to wind up in jail because you file a criminal complaint against them. I guarantee you they're going to honor their oath. They have to. And furthermore, one of them can perjure his oath, and the other ones will get them. Because again, it comes down to, yeah, one of them might perjure his oath, but they all won't, I guarantee you. Quote, the exclusive jurisdiction which the United States have in forts and dockyards ceded to them is derived from the express assent of the states by whom the cessions were made. It would be derived in no other manner because without it, the authority of the state would be supreme and exclusive therein, unquote. And that's U.S. versus Bevins. That's Book 16, U.S. Supreme Court, page 336. That's also found at 3 Wheat at page 350. That's 1818. The point here is that, again, they have exclusive jurisdiction in federal enclaves. They're talking about federal enclaves here, and I happen to know a little bit about this because I was Speaker of the House of Representatives for the Republic of Texas for a year and a half. And so we talked about this kind of stuff because and we did an investigation. And, for example, in Texas, we wanted to find out how many federal enclaves there are in Texas. There are none. There are no federal enclaves in Texas. And yet some of the largest military bases in the country are in Texas, like Fort Hood. And in San Antonio, there's Lackland Air Force Base, which is the Air Force Training Center. There's military bases all over Texas. And yet there's none of them are federal enclaves. And so they don't have exclusive jurisdiction in those areas. And so the point being is that they don't have any authority. They don't have a shred of authority, but the burden's on you to point that out to them. And once you do, yeah, everything will change for you. It's not going to change for the other guy because he's still a slave. But guaranteed for you, they're going to leave you alone. Due process of law. They have no right to do anything to us except by common law. And this is found in Article 5, an amendment for the Constitution for the United States of America. Now, you might notice that I call it Article 5, an amendment. Well, that's how it's written in the Constitution, okay? And if you call it something else, well, there's actually two constitutions. There's a corporate charter and there's a constitution. And both of them are very similar, except that the real Constitution only goes up to 13 amendments because after that, they don't have any authority. And so then the 14th and the 15th and the current 13th, all these other amendments are in the corporate charter. And so then in the corporate charter it's called the Fifth Amendment. But in the real Constitution it's called Article 5, an amendment. And so it's all in the words you use and how you describe it and everything. It's all everything. You know, they go and say anything you say can and will be used against you in a court of law. Well, how difficult is that to understand? That's exactly what they do. And it's all from your words that they take it. And so if you say, I'm in the city of Fort Worth, well, you're telling them you're in a corporation. And only a corporation can be in a corporation. It's like the movie The Matrix. If you're in the Matrix, you're a fictitious entity by definition. So it's all in what you say. And you have to understand the law and know what it is you're talking about. So anyways, in Article 5, an amendment for the Constitution for the United States of America, it says, quote, no person shall be deprived of life, liberty, or property without due process of law, unquote. Quote, the principle that no person should be deprived of life, liberty, or property except by due process of law did not originate in the American system of constitutional law, but was contained in the Magna Carta, sometimes referred to as Chapter 29, confirmed on the 19th day of June, 1215, declared, quote, no freeman shall be taken or imprisoned or seized or outlawed or exiled or any way destroyed, nor shall we go upon him nor send upon him, but by the lawful judgment of his peers or law of the land, unquote. It has been said that the principle was known before Magna Carta and that it was originally designed to secure the subject against arbitrary action of the Crown and to place him under the protection of the law. It is settled beyond question that this principle came from England to America as part of the common law and has been a fundamental rule in common law. When first adopted in Magna Carta, the phrase law of the land had reference to the common law and has been a fundamental rule in common law. And that's found in 16 American Jurisprudence, 2nd edition, Constitutional Law, Section 543. So, again, do you know who you are? Law of the land means common law, and that's Justice O'Neill in State v. Simmons, 2 Spears, 761, 1884. It's also Justice Bronson and Taylor v. Porter, which we just cited here a little while ago, at 4 Hill 140, 1843. You can be a national without being a citizen. Citizenship is part of a political community. The U.S. passport application even talks about non-citizen nationals. And so what I do when I fill out the passport application is I line out U.S. citizen, and and where it doesn't specify, I write in American national. Quote, it is, however, true in all common law countries and has always and consistently been held that the wife and minor children take the nationality of the husband and father. That is common law doctrine, unquote. And that's found at in page 12 Federal Report, 2nd edition, page 135. Quote, the common law does not require a citizen to identify himself or carry identification of any sort. Therefore, while it may be the mark of a good citizen to identify himself when asked to do so, a police officer must not use force to compel someone to identify himself when he refuses. Otherwise, he will be guilty of criminal assault and liable to civil damages, unquote. And that's taken from the Police Manual of Arrest, Seizure, and Interrogation, 8th edition by the Honorable Roger E. Salhaney, page 94. That is actually a Canadian book, but this is talking about common law. And so that's why I make up my own ID, and that's why it works so well, because at common law, I don't have to give them anything. And so when I present them my ID, I tell them I need to point a couple things out about this. First of all, it's a government document. It says right here it's a government document. It's verified by an officer of the court. It's a certified copy, and it's a apostille for international commerce. And then once I point that out to them, then they take it, and they'll say something like, is there a birth date on here? And I'll say, I have no firsthand knowledge of the day I was given birth. Do you have firsthand knowledge of the day you were given birth? And they'll say no. And so then I'll say, and any evidence of any birth date anywhere is hearsay evidence and inadmissible as evidence in a court of law. And they'll shut up, and I'll never hear another word about that again. I can't tell you how many times I've done that. Quote, similarly, a person cannot be convicted of resisting a peace officer in the execution of his duty unless the officer was acting strictly within the limits of his powers and duty. If the officer makes an unlawful arrest, then there is a common law right to resist that arrest, unquote. Police Manual of Arrest, Seizure, and Interrogation, 8th edition by the Honorable Roger E. Salhaney, page 96. So again, and that's why I put in my documents that I have the right to resist an unlawful arrest with lethal force if necessary, because I have that common law right. And if they arrest you and it's an unlawful arrest, then it's an assault. And so by me, I serve them with that, and I tell them that unless you witness me commit a felony, it's going to be an unlawful arrest, and that's true. And that's what the courts have said. Quote, at the outset, I must express my shocked amazement at the contention of counsel for the minister that the claim of a resident of Alberta to a driver's license and consequently to drive upon the highways of Alberta is a privilege and not a right. Since time immemorial, the Queen's subjects have been free to move along the Queen's highways, provided only they kept the Queen's peace, unquote. And that's the Chief Judge, J. Egbert, in Regina X. Rel. Christopherson versus Minister of Highways, and that's found at 28 Western Weekly Reports, page 38. That's an Alberta court case, Alberta Court of Appeals, or I think it's at that time, I think it was the Supreme Court, because I think it's in like the 40s. Anyways, there's a principle of law called stare decisis. It's the doctrine of precedent under which it is necessary for a court to follow earlier judicial decisions. When the same points arise again in litigation, the rule of adherence to judicial precedents finds its expression in the doctrine of stare decisis. This doctrine is simply that when a point or principle of law has been once officially decided or settled by the ruling of a competent court in a case in which it is directly and necessarily involved, it will no longer be considered as open to examination, unquote. And that's Black's Law Dictionary, 8th edition, page 4403 to 4404. So, again, we were talking about that earlier about stare decisis. There's another principle of law called res judicata, and it's a Latin, again, a thing adjudicated. We use a lot of Latin in here because it's all coming from Rome. And the definition of res judicata is an issue that has been definitely settled by a judicial decision. In other words, if I was to get a divorce, what does the Bible say? The Bible says, give her a writing of divorcement, okay? And so that's exactly what I do, is it would never go to court. I would make up a document, and it would say something like, I hereby divorce myself of you, and you're free to go and marry some other man, and get it notarized, and take it to the county recorder and record it, and then I'd serve it on the court, and I'd say, this case has already been decided. You got nothing to say about this. And that would be the end of it, because it's res judicata. As I am the king, I am the judicial power citizen, and we're going to talk about that. All courts go by precedent except for a common law jury of the people. Okay? A common law jury of the people can do literally anything they want. And I told you earlier about 1802, the U.S. Supreme Court convened a common law jury to tell them what the law was on a certain matter, and more on this subject will be covered in the presentation entitled Does Your Government the Ultimate Solution? Quote, the judicial power is the power to hear those matters which affect life, liberty, or property of the citizens of the state, unquote. And that's Sapulpa versus Land, 101, Oklahoma 22. It's also found at 223 Pacific Reports, page 640, and it's also found at 35 American Law Reports, page 872. And so I am a judicial power citizen. As a sovereign, I am a judicial power citizen. I can hear those matters which affect life, liberty, or property of my peers. That's citizens of the state. Nobody else, U.S. citizens, are not judicial power citizens. Quote, and because it brings into action and enforces this great and glorious principle that the people are the sovereign of this country, and consequently that fellow citizens and joint sovereigns cannot be degraded by appearing with each other in their own courts to have their controversies determined, unquote. And that's Chisholm versus Georgia, 2 Dallas, page 440. This is so excellent, because what they're saying is that that for me to appear in the corporate commercial courts is degrading, and my court is a jury of my peers, and that is it. And so when they try to attack me, I'll tell them that I am degraded by having to appear here. Anyways, they haven't tried. They put me down as sovereign in their system, remember? Quote, Jurisdiction must be raised before making any plea to the merits, if at all, when it arises from formal defects in the process or when the want of jurisdiction over the person, unquote. That's Smith versus Curtis, 7 California reports, page 584, and there's actually a whole bunch of citations here, Massachusetts, Missouri, all sorts of stuff. So, again, the burden is on you to challenge jurisdiction. You have to do it right up front. It's like if say the IRS says to you, they say, you owe $50, and you say back, well, I paid you $25. You just admitted the contract. Right there, by making that statement, you admitted the contract. Now you're debating the terms of the contract. And so if you're going to challenge the existence of the contract, you've got to do that before you do any of that stuff. And that's called a demur, by the way, at common law. And so if they come up to you and say you owe us $50, and you say, yeah, well, I filed last year, you're debating the terms of the contract. If you talk about anything about their rules and regulations, you're debating the terms of the contract. You just gave them the contract. By definition, that's exactly what you did. You just gave them the contract. And now we're going to talk about terms. And if you want to talk about the terms, well, you're a slave, and you don't have any rights, and we can change the terms all we want. And that means absolutely nothing. And so you just lost your case. Quote, a court of general jurisdiction is presumed to be acting within its jurisdiction till the contrary is shown. Okay? See, now you're starting to understand where all this stuff is coming from. They presume they have jurisdiction until you challenge it. And again, you have to challenge it in the right way. Quote, there is no common law judicial immunity, unquote. And that's Pulliam versus Allen, 104, Supreme Court, 1970. And that other case is Brown, Jurisprudence, Section 202, and it's also Wright versus Douglas, 10 Barb, New York, page 97, and it's also Town of Huntington versus Town of Charlotte, 15 Vermont Reports, page 46. Quote, the property which every man has in his own labor is, as it is, the original foundation of all other property. So it is the most sacred and inviolable. The patrimony of the poor man lies in the strength and dexterity of his own hands, and to hinder his employing his strength and dexterity in what matter he thinks proper without injury to his neighbor is a plain violation of the most sacred property, unquote. And that's Butchers Union Company versus Crescent City, Colorado, 111 U.S. 764, U.S. Supreme Court. Quote, the right to follow any of the common occupations of life is an unalienable right. It was formulated as such under the phrase pursuit of happiness and the Declaration of Independence, unquote. And that's Algier versus State of Louisiana, 165 U.S. 578, U.S. Supreme Court. Quote, in this, as in other respects, a constitutional provision must be interpreted in the light of the common law, the principles of history of which were familiarly known to the framers of the Constitution. The language of the Constitution, it has, as had been well said, cannot be understood without reference to the common law. And that's found at 1 Kent Commission commentaries. And that's a U.S. Supreme Court case, Kepner versus United States, 195 U.S. 100. Okay, it looks like somebody's got a question. Oh, that's okay. Did I hear that right? It's a privilege and not a right to travel? No, you didn't hear that right. It's a right to travel. Most quotations say it's a right, and now I'm confused. Yeah, I don't know where I said it was a privilege. It's not a privilege. It's a right. It's a right to travel. Quote, it is one of the fundamental maxims of the common law that ignorance of the law excuses no one and that's Daniel versus Dean, 1905, 2 California Appeals, page 421, and that's also found at Book 84, Pacific Reports, page 332. So what we're talking about here is basically court citations that talk about common law rights and what those rights are. Now remember, common law rights are not defined, so these are the only ones that they talked about. Your rights are unlimited. Quote, a sovereign is exempt from suit not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends, unquote. And that's Kawanakoa versus Polyblank, 205 U.S. 349. That's U.S. Supreme Court, 1907. Yeah, why don't we go ahead and take a break, and I'll come back after a break and continue on. Good evening, everybody there in Radio Land. This is Glenn Winningham, House of Fern, and we're talking about common law, and this is Do You Know Who You Are? And you're listening to These Changing Times radio website, and we're talking about common law. I have a website for anybody that's interested. It's www.sovereigntyinternational.info. I've also got some groups. I've got a group on These Changing Times radio website under the groups link. It's called sovereigntyinternational.info as well. I've also got a couple private groups. There's one at Yahoo and one at Google, and those ones are called Administrating Your Public Servants. And you can reach those. You have to go there and request to join, but usually it's not a problem. And so I've also got a bunch of videos and things like that that are available if you go to my website, www.sovereigntyinternational.info. You can, a lot of those videos are available on YouTube, but maybe you don't want to download them, and so you can order them on DVDs. There's also, when you order the YouTube videos, you get free unlimited upgrades to the PowerPoint presentations. You'll get a bunch of files, and you'll get free unlimited upgrades to the PowerPoint presentations. But if you do order the videos, don't forget to ask for the upgrades, because if I don't know that you're looking for them, I don't automatically send them out unless you request them. So you need to, I like to remind people about that. So these are the presentations that I'm going through right now, and the reason that you get upgrades is because I update them, every time, every day just about. I'm up there. I'm putting new court cases in them and organizing them a little bit different, and I'm playing with them all the time. And so so you want all the latest court cases, and so about every 6 months I would suggest you might want to email me and let me know that you got the package and who you are, and that you would like an update. And so then I'll email it to you. That's pretty easy. Just email the latest files. Anyways, okay, so we're talking about sovereignty, about common law. What happened was I was visited by the Texas State Police and the FBI back a year ago last March, and at that time they told me 3 times that I'm listed as sovereign in their system. And so what we're talking about is how that happened and how anybody can do it, and what my procedure is, and it's really not that complicated, but you got to think about it, and the whole idea of what's going on and how it's happening, and how we're all kings and queens, but we've become involved in what the courts view to be contracts, but all we have to do is we're the king. So all we got to do is tell them, and you just watch them scatter, like it's turning the lights on and the roaches scatter. It's amazing how that works. But so that's what we talk about. Okay, so quote. The courts of England will take judicial notice of the status of a foreign sovereign and will not take jurisdiction over him unless he voluntarily submits to it, unquote. And that's 1 QB 149, I guess that's Queen's Bench, and 1894. Quote, a foreign sovereign brought suit to restrain the defendants from using a fund in a certain way, and the defendants set up a claim for damages. It was held that the court had no jurisdiction over such claim, unquote. And that's also 1CH 190, 1898. Again, do you know who you are, okay? Remember the one that I read just before the break was, quote, a sovereign is exempt from suit, not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends, unquote. And that's Kawanakoa versus Polyblank. That's U.S. Supreme Court, 205 U.S. 349. And the authority that the government operates on, remember there's court cases that say that the authority that it's delegated by we the people. So their authority comes from me. And so, therefore, I'm exempt from suit. And that would be what I would be arguing is you don't have any authority over me. Okay, so keep moving here. Quote, when a foreign sovereign comes into court for the purpose of obtaining a remedy, then by way of defense of that proceeding, by counterclaim if necessary, to the extent of defeating the claim, that person sued may file a cross-claim for the purpose of enabling complete justice to be done between them, unquote. And that's 29 WR 125 per James L.J. Quote, it is a general rule that the sovereign cannot be sued in his own court without his consent, and hence no direct judgment can be rendered against him therein for costs except in the matter and on the condition he has prescribed. And that's 40 Louisiana Reports, page 856. And that is taken from Bouvier's Law Dictionary, Volume 1, 1897. Quote, sovereignty itself is, of course, not subject to law, for it is the author and source of law, but in our system, all sovereign powers are delegated to the agencies of government. Sovereignty itself remains with the people, by whom and for whom all government exists and acts, unquote. And that's Equal versus Hopkins, 118 U.S. 356. That's U.S. Supreme Court, okay? And so and let's look at that a little bit. It says sovereign powers are delegated to the agencies of government. I mean, that speaks volumes. That means that they're delegated by me. I delegated them. And since there's not too many people out there that are claiming to be sovereign, there's not many sovereigns around. I might be the only one. That would make me the absolute king. Again, do you know who you are? Quote, no action can be taken against a sovereign in the non-constitutional courts of either the United States or the state courts, and any such action is considered the crime of barratry. Barratry is an offense at common law. And that's State versus Batson, 17 Southeast Report, 2nd edition, page 511. So again, do you know who you are? And they're saying here that all the courts in the United States or the states, they're all non-constitutional. They don't have any authority. It's all corporate commercial courts. You go to Dun & Bradstreet and you'll find every one of them listed there as a for-profit corporation. And so all you need to do is bring that stuff up. You know, where's your authority? Where's your authority to hear this matter? This is a military courtroom you brought me in here. Where's your authority? Quote, if the common law can try the cause and give full redress, that alone takes away the admiralty, unquote. And that's Ramsey versus Allegree, 12 Wall, page 611. Quote, and Kriebel's reports, page 500, quoted by Brown, it is expressly said that without a stipulation, the admiralty has no jurisdiction at all over the person, unquote. And that's Ramsey versus Allegree again, 12 Wall, 611. Quote, the common law is the standard by which to ascertain what are proper cases for a prohibition to a court of admiralty and not the civil law, unquote. And that's Baines versus the schooner James and Catherine, and that's federal cases, page 576. So again, you know, this is all different things that they're talking about in common law. In other words, with admiralty, in order for admiralty to have jurisdiction, there's got to be a contract. There absolutely has to be a contract. And so, again, you just point out to them that there's no contract, and they don't have authority. And now you're putting them in a position where they're perjuring their oath of office. Otherwise, they can presume you're a U.S. citizen, that you're a slave, and it's because they presume you're a U.S. citizen. Remember, a court of general jurisdiction presumes that they have jurisdiction until something says otherwise. And so they presume things and until you defeat them, and so then when you serve them with a letter defeating their presumptions, everything changes. Quote, a refusal on the part of an individual lawfully called upon to assist the officer in putting down a riot is indictable. And that's found at 1 Carr and Marsh, page 314. I'm guessing Carr and Marsh is a set of books in the remember I was talking about that 800 years of jury trial decisions? I'll bet you that is one of the books, one of the sets. And that's found in Bouvier's Law Dictionary, 1856 edition. Now, and the reason I'm mentioning this, okay, is that along with common law rights come common law responsibilities. And this goes back to posse comitatus. And that's why I always tell the police that I appreciate the work you do. We need people like you to hunt down murderers and thieves, and I have no idea what you get paid, but in my opinion, it's not enough. And it's true. And I really do feel that way because if they weren't doing it, they'd be running up posses, and I'd probably have to be on them. And I would rather not, quite frankly. I'd rather let someone that really knows what they're doing, that's trained in how to do it, as long as he knows what his lawful duty is. And so that's why I always tell them, I appreciate the work you do, and I tell them that if you call upon me to come to your aid, I'll be there for you, and I will, because that is my common law responsibility. Quote, the term citizen in the United States is analogous to the term subject in the common law, unquote. And that's State versus Manuel, 20 North Carolina Reports, page 122. It's also found at Book 14, Corpus Juris Secundum, page 430. Now, so the important thing here is that, you know, a lot of people run around saying, no, I have common law rights. Well, you're not. Common law is what they're doing you with. I can tell you right now, that's exactly what's happening, because if you're telling them that you're a U.S. citizen, then you're telling them you're a subject, because at common law, a U.S. citizen is a subject. That's what this court case says. And a subject is a slave. That's exactly what a subject is. And so a subject is a piece of property, and you just turned yourself into a piece of property. And why do you think they ask you that stuff? You know, one time I was going across on I-10. I had my wife and kids with me, and my wife was really intimidated by border guards and the Border Patrol and those kinds of people. And a lot of it's because she doesn't have a green card. But I keep telling her that at common law, the wife takes on the nationality of the husband, but she just, you know, she doesn't want to learn it, and she's just so intimidated by it. And now she's living in Canada, and I'm living in Delaware, and you know, she's happy, and I'm happy, and so at any rate, so the bottom line is though is that we were driving across the southern states, in Texas. We were actually in Texas on Interstate 10, and they have these two U.S. Border Patrol stops. There's one in New Mexico when you're going west, and there's one in Texas when you're going east. And so we came up to this one in Texas going east. And I pulled out my U.S. passport. When I was going west, it's amazing, because when I was going west, they would, they had all these cameras, okay? They had cameras and lights and all this stuff. And so you know that they're scanning your license plate to see who you are as you're coming up to the little, there's a little guardhouse with the Border Patrol guy. And there's a big long line of traffic, you know, maybe 50 vehicles. So it takes, you know, maybe 5-10 minutes before you get up there, and you see the guy coming out of this little guardhouse, and he goes and talks to whoever's in the vehicle, and then he goes back in, and the next car pulls up, and he comes out and talks to him, and then the next car pulls up, and he comes out and talks to him. Well, when I come up, about 4 vehicles in front of me, he goes in his guardhouse and just stays there. And then the 4 vehicles drive by, and I drive by, and a couple of vehicles behind me, and then he comes out and starts talking to them again. And I really think that they have me down in their system, leave this guy alone. Because that's happened on more than one occasion going west. Now, going east, it's different. And for that reason, I believe that it has something to do with the governor of the state. I really do. And so I think I'm going to administrate the Texas governor and tell him to get him off my case. But anyway, so when we're going west, or east, I should say, this is in Texas, they stopped me and they wanted to see, you know, they said U.S. citizens. And what I did is I pulled out my passport. It's a U.S. passport. And I just said this. I said American nationals. And that's all I said. And he looked at it, and then he looked at my wife and kids, and he said, "So where are you guys from?" And I said, "Keller, Texas." And he said, "Have a nice day." And that was the end of it. And because American nationals, remember that court case that we read? At common law, the wife and minor children take on the nationality of the husband. And so that's what I was telling them, is we're not U.S. citizens. I'm an American national, and this is my wife and children. And he has no right to talk to them. He talks to me. He didn't talk to them. He just looked at them, and we were on our way. And so, again, do you know who you are? Quote, so if you're going to call yourself a U.S. citizen, even if you pull out a U.S. passport, you can be an American national and have it pull out a U.S. passport. It even talks about non-citizen nationals in the passport application. But if you're going to say you're a U.S. citizen, then you're telling them that you're a slave. Quote, the right to travel is a part of the liberty of which a citizen cannot be deprived without due process of law under the Fifth Amendment, so much as conceded by the Solicitor General. In Anglo-Saxon law, that right is emerging as least as early as the Magna Carta, unquote. And that's found in the U.S. Supreme Court case called Kent versus Dulles. That's found at 357 U.S. 160. Now, you could use this in England. You could use this in any common law country, because they're saying in Anglo-Saxon law that right is emerging at least as early as the Magna Carta, and that's the U.S. Supreme Court. And it says the right to travel is part of the liberty which the citizen cannot be deprived without due process of law. They're talking about the Chapter 29 of the Magna Carta. So this case could be used in England or Canada or anywhere. Quote, the right of the citizen to travel upon the public highways and to transport his property thereon, either by carriage or by automobile, is not a mere privilege which a city can prohibit or permit at will, but a common law right which he has under the right to life, liberty, and the pursuit of happiness, unquote. And that's Thompson versus Smith, 154 Southeast 579. Quote, the right to use the highway for the purpose of travel and transportation is not a mere privilege, but a common fundamental right of which the public and individuals cannot rightfully be deprived, unquote. And that's Chicago Motor Coach versus Chicago, and that's 169 Northeast Reports, page 221. Quote, complete freedom of the highways is so old and well established a blessing that we have forgotten the days of the robber barons and toll roads, and yet under an act like this, arbitrarily administered, the highways may be completely monopolized. If through lack of interest the people submit, then they may look to see the most sacred of their liberties taken from them by one or more, by more or less rapid encroachment. And that's found at Robertson versus Department of Public Works. And that's 180 Washington 133. So it's Washington Reports. Quote, personal liberty largely consists of the right of locomotion to go where and when one pleases, only so far restrained as the rights of others may make it necessary for the welfare of all other citizens. The right of the citizen to travel upon the public highways and to transport his property thereon by horse-drawn carriage, wagon, or automobile is not a mere privilege which may be permitted or prohibited at will, but the common right which he has under his right to life, liberty, and the pursuit of happiness. Under this constitutional guarantee, one may therefore, under normal conditions, travel at his inclination along the public highways or in public places, and while conducting himself in an orderly and decent manner, neither interfering with nor disturbing another's rights. He will be protected not only in his person, but in his safe conduct. And that's found at American Jurisprudence, first edition, Constitutional Law, section 329, page 1135. Quote, the right to operate a motor vehicle upon the public streets and highways is not a mere privilege. It is a right or liberty, the enjoyment of which is protected by the guarantees of the federal and state constitutions, unquote. And that's Adam versus City of Pocatello, 416 Pacific Report, second edition, page 46. Quote, A license is a privilege granted by the state and cannot possibly exist with reference to something which is a right, to ride and drive over the streets. If we allow the city of Chicago to require the licensing of horseless carriages, how long be the city of Chicago would want to require a license to ride a horse to walk upon the streets, unquote. And that's City of Chicago versus Collins et al., 51 Northeast Reports, page 907, that's 1906. Quote, it is a rule at common law, the reason applies in equity and other civil law cases, that if a party can plead a fact material to his defense and omits to do it at the proper time, he can never avail himself of it afterwards, unquote. And that's Penn Hallow versus Doan's Administrators, 3 U.S. 54, 1795. Now, this is extremely important because that's why I serve them with my documents long before they ever see me on the radar, because they can't say I didn't plead it at the right time, okay? And so I serve them with my documents, and I tell them that you have no more authority over me than a Walmart rent-a-cop, and they don't. And so if I try and plead that after the cop has stopped me, then they're going to basically ignore it. But when I serve it on them up front, then everything changes. There's a principle called laches. That's unreasonable delay in pursuing a right or claim, almost always an equitable one, in a way that prejudices the party against whom relief is sought, and it's also termed sleeping on rights. It's an equitable doctrine by which the court defines relief to a claimant, or denies, I should say. Let's start that over again. It says, the equitable doctrine by which a court denies relief to a claimant who has unreasonably delayed in asserting the claim, when that delay has prejudiced the party against whom relief is sought. The doctrine of laches is an instance of the exercise of the reserved power of equity to withhold relief otherwise regularly given, where in the particular case the granting of such relief would be unfair or unjust. And that's taken from Black's Law Dictionary, 8th edition, page 2553 to 2554. So the reason I mention this is that in the martial law presentation, we talk about how the equity in martial law and color of law presentation, we talk about courts of equity, and the court of equity has to follow the common law normally. But under martial law, in the martial law presentation, under martial law, there is no common law. And so then a court of equity can do literally anything it wants. And the judges will actually tell you that I can do anything I want in this courtroom. And they're 100% right, because there is no common law in that courtroom. That's not to say you don't have access to common law, but in that courtroom there's no common law. So anyways, the point being is that they're under their equitable powers. The equity is the power of the court to basically bend the rules. And even at common law, sometimes common law doesn't provide an adequate remedy. A good example is, say, for example, I go through a stop sign. And at common law, if I hit some guy and go through a stop sign and hit some guy, then I have to pay. He's married and got kids. I have to pay to support his wife for the rest of her life, and I have to pay to support his kids until they're the age of majority. Well, you know, that might not be a very good remedy. And so there's other cases where common law, at common law, if I don't pay it, then they'll just take me out back and stone me. Okay, that's the choice. There's no jails at common law. The choice is either to do that or they take you out back and stone you. And that might not be a very good remedy in every situation. And so the lady could go into court and argue that that another remedy might be better. And so you know, all she has to do, and the court can basically ignore the common law and do whatever he wants to do. That's assuming that common law is there. Now, if it's martial law, then there is no common law. And so then it's whatever the court can do, literally anything he wants, and things are quite a bit different. And that's what you see today, because the government's bankrupt, everything's under martial law, and that's how it works. Because the government's bankrupt and under martial law, there's no common law. Therefore, they have to enact statutes that codify common law crimes, like, for example, misprision of felony, which is a common law crime, and it's found at Title 18 United States Code Section 4. Or rights violations under the color of law. That's found at Title 18 United States Code Section 241 and 242. Or extortion under color of law. That's found at Title 18 United States Code Section 872. Many common law crimes are not covered by statutes. Like, for example, barratry. We talked about that. There's no statute that makes barratry a crime. So barratry is not a crime under martial law. And you have to understand that. Quote, where there is no jurisdiction, there is no judge. The proceeding is as nothing, such has been the law from the days of Marshal Saya. And that's found in 10 Koch reports, page 68. And that's also found in U.S. Supreme Court case called Bradley versus Fisher, 13 Wall, 335. So the point being is that, again, the burden's on you to challenge jurisdiction and do it at the right time. You have to do it at the right time. That's why I tell them in my paperwork, you have no more authority over me than a Walmart rent-a-cop. I'm telling them, you don't have jurisdiction over me. And quote, the claim and exercise of a constitutional common law right cannot be converted into a crime. Miller versus U.S., 230 Federal Reports, page 486. And when I say common law, it doesn't say common law in there. It says, quote, the claim and exercise of a constitutional right cannot be converted into a crime, unquote. Well, when they're talking about constitutional rights, they're talking about common law rights. That's exactly what they're talking about. And the courts have said that. Quote, there can be no sanction or penalty imposed upon one because of his exercise of constitutional rights, unquote. Well, remember what I said just a minute ago. A constitutional right is a common law right. Schur versus Cullen, 481 Federal Reports, page 946. Quote, the claim and exercise of a constitutional right cannot be converted into a crime. That's Miller versus U.S., 230 Federal Reports, page 46. Quote, no state shall convert a liberty into a privilege, license it, and charge a fee therefore, unquote. And that's Murdoch versus Pennsylvania, 319 U.S. 105. That's, again, U.S. Supreme Court. Quote, if a state converts a right or liberty into privilege, the citizen can ignore the license and fee and engage in the liberty with impunity. And that's Shuttlesworth versus City of Birmingham, Alabama, 373 U.S. 262. It's, again, U.S. Supreme Court. Quote, generally speaking, an account stated is based on the common law concept that an implied contract arises when the debtor, the service as in the IRS, submits to the creditor, the taxpayer, a statement of final balance due on an account, and the creditor agrees to accept the proposed balance to close the account. And that's C. Bonwit, Teller and Company versus United States, 283 U.S. 258, 1931. And so what they're talking about, again, is common law. And if someone offers a settlement and you agree to it, you know, then I guess it's like, again, and this is what the IRS does all the time. Think about it. If they come up, if some guy comes up to you on the street and says, you owe me $50, and you pay him $50, well, then you must have owed it. And the burden's on you to challenge it. If some guy comes up to you on the street and says, you owe me $50, and you say, well, I paid you $25 already, well, you just admitted the contract. But that's what we do with the IRS all the time. And so if someone comes up on the street and says, you owe me $50, and you say, is there a contract here? Where's the contract? And then everything changes because you're challenging jurisdiction is what you're doing. You're saying there's no contract here. But until you do that, they're going to presume that there is a contract, especially if you go start arguing the terms of the contract. That's exactly what happens. Quote, all persons in the United States are chargeable with knowledge of the statutes at large. It is well established that anyone who deals with government assumes the risk that the agent acting on the government's behalf has exceeded the bounds of his authority, unquote. And that's Bullo versus Federal Reserve Bank of San Francisco, 650 Federal Report, 2nd edition, page 1093. And that's the Ninth Circuit, so that's a Court of Appeals case, 1981. Quote, persons are not taxpayers who are not within the system and can obtain no benefit by following the procedures prescribed for taxpayers, such as the filing of claims for refunds, unquote. And that's Economy Plumbing and Heating versus U.S., and that's found at 470 Federal Report, 2nd edition, page 585. Quote, the revenue laws are a code or a system and regulation of tax assessment and collection. They relate to taxpayers and not to non-taxpayers. The latter are without their scope. No procedures are prescribed for non-taxpayers, and no attempt is made to annul any of their rights and remedies in due course of law. With them, Congress does not assume to deal, and they are neither the subject nor the object of the revenue laws. And that's Long versus Rasmussen, 281 Federal Reports, page 236. So the point I'm making here is that they know that there are those who are non-taxpayers, okay? They are, if they're even talking to you, they seem to think that they have some authority. And so therefore, you're involved in some contract with them. That's really what it comes down to. And you need to understand that and defeat it. That's exactly. And what do? The first thing you say is, where's the contract? I want to talk about the contract. Quote, this is taken from Article 4 of the Articles of Confederation. Quote, the better to secure and perpetuate mutual friendship and intercourse among the people of the different states in this union, the free inhabitants of each state, paupers, vagabonds, and fugitives from justice excepted, shall be entitled to all privileges and immunities of free citizens in the several states, and the people of each state shall have free ingress and regress to and from any other state, unquote. And that's again Article 4 of the Articles of Confederation. Now, the interesting thing is that they're talking about that everybody has free ingress and regress. Okay, that means they can come and go as they please, except paupers, vagabonds, and fugitives from justice. Well, think about it. How many Federal Reserve notes you got in your wallet? If that's all you got in your wallet, then you're bankrupt. All you have is a bunch of IOUs. You're bankrupt. If all you got's Federal Reserve notes in your wallet, you don't have any money. They're just nothing but IOUs. They're a bunch of coupons is what they are. At common law, a vagrant doesn't have any rights, even at common law. Again, I can't tell you how many times that people are being done by common law. They don't understand the law. If all you have in your wallet is Bank of Canada notes or Federal Reserve notes or other IOUs, they're all IOUs, then you have no money, and you are a vagrant. At common law, there's no jails. All jails are private. In England, the Archbishop of Canterbury owns all the prisons. Jail is a benefit because common law penalties are very severe. So again, if I go through a stop sign and hit some guy and kill him, and then at common law, I have to pay to support his wife for the rest of her life and to pay to support his kids for till they're the age of majority. And so now all of a sudden jail is starting to look pretty good. And so I go and spend a couple of years in jail. Whoop-de-doo. That saves me. Now I can come out and I can make all sorts of money and it's mine. Now as far as that lady and her husband, or I should say and her kids, they're going to be on welfare and they'll be slaves and all the rest of it. And so I'll certainly have caused them damage. But I'm going to get off the hook. Again, the whole system is very satanic in my opinion. There are people who when they're in the so-called courts, they'll tell the judge that they waived the benefit, And that's what they're saying is that I waive the benefit of jail. That's what they're saying. Quote, former U.S. Supreme Court Chief Justice Rehnquist said that there's not one person that was in jail that had not agreed to it. And that's exactly what they do. They get your consent. What they'll do is that judge will be sitting up there and under law merchant, all you have to do is commit a dishonor, and there's a contract. It creates a contract. And so if you don't answer them right every time, if you dishonor anything, then that's the contract. And he'll be up there. He makes three kinds of bonds. There's a bid bond, a performance bond, and a payment bond. And they circulate those things on Wall Street. And there's people that have found their bonds based on their court case. They'll find that bond circulating at Fidelity Investments worth millions of dollars. Posse comitatus. That's Latin. It's the power or force of the county. The entire population of a county above the age of 15, which a sheriff may summon to his assistance in certain cases, is to aid him in keeping the peace, in pursuing and arresting felons, etc. And that's found in Black's Law Dictionary, 6th edition, 1990, and that's in a court case, Williams versus State, 253 Arkansas, 973, and it's 490 Southwest Report, 2nd edition, page 117. In order for a member of the sovereignty to become subject to regulation in any way, they must agree to it. As with any contract, it has to be knowing, willing, and intentional. So that's the issue, is where's the contract? Where did I agree to this? That's what Kat always says, and they're left helpless because they can't produce anything. So they go away and leave her alone. Quote, the state citizen is immune from any and all government attacks and procedure, absent contract. See Dred Scott versus Sanford, 60 U.S. 393, or as the Supreme Court has stated clearly, every man is independent of all laws except those prescribed by nature. He is not bound by any institutions formed by his fellow men without his consent, unquote. And that's Cruden versus Neal, 2 North Carolina Reports, page 338. It's also found at 2 Southeast Reports, page 70. Okay. Quote, the rights of individuals are restricted only to the extent that they have been voluntarily surrendered by the citizenship to the agencies of government, unquote. And that's City of Dallas versus Mitchell, 245 Southwest Reports, page 944. Again, that sounds like U.S. citizens. Okay, the rights of individuals are restricted only to the extent that they've been voluntarily surrendered by the citizenship to the agencies of government. That sounds like U.S. citizens. And what this is now is I'm going to go over this letter by this Arizona senator. And this letter, by the way, has been uploaded to the group. It's uploaded to my group at Yahoo, but it's also uploaded to the group on These Changing Times radio website. And this letter is a certified letter, certified by a notary public. It says that the certification says here, I, Howard Wayne Stump, do solemnly state that this is an exact and true copy of a letter that I wrote on December 10th, 1985, while serving in the State Senate of Arizona, and signed in my presence this 14th day of January 2004, and that's the notary. And so then the notary is certifying that Wayne Stump signed the letter, and then it's apostilled, and an apostille certifies that it's a notary, a true notary. So you got basically a very powerful, it's a perfect record, basically. I mean, you could admit this in court, and they'd have to accept it. Anyways, okay, so this has got Arizona State Senate letterhead on it, and as dated December 10th, 1985, it's a letter directed to Ralph Milstead, Director of Public Safety, State of Arizona, and it says, Dear Director Milstead, it has come to my attention that numerous individuals in our state have rescinded all of their contracts with the United States federal government, the state of Arizona, and each of its political subdivisions, establishing themselves as freemen under the organic national constitution of the Republic of the United States of America. Consequently, they may be driving without auto registration, driver's license, or any other evidence of contract. Did you know all that stuff is contracts? That's exactly what they are. So it goes on. Because many law enforcement personnel may be unaware of the contractual nature of auto registration and driver's licenses, it is conceivable that this situation may lead to confrontation between these individuals and law enforcement personnel. I urge you to inform yourself of your personnel about this matter as soon as possible. If you would like to be briefed by someone knowledgeable about this subject, please contact me. In the meantime, inasmuch as this procedure is entirely appropriate when properly carried out, I would like to be personally notified of every such instance of confrontation in order that the persons involved and the public officials involved may be apprised of the correct procedure and the appropriateness of their actions on the part of each concerned. And then he goes through some notification. He says, my office phone number is, and I am requesting to be notified of the names and incidents along with the addresses and phone numbers of the participants of any such confrontations arising from the exercise of a person's freeman status in order to evaluate the outcome of properly rescinded contracts. And then it's signed by Wayne Stump, Arizona Senator. So all of that stuff is contractual. That's exactly what it is. They've agreed to it. And that's why Arizona Senator, I understand Wayne Stump has passed away, but we do have some very wonderful public servants. And as with anything, if there's criminals, you root them out and prosecute them. Quote, state citizenship is a vested substantial property right, and the state has no power to divest or impair these rights, unquote. And that's Favot versus Kingsbury, 1929, 98 California Appeals, page 284, and that's, right. Oh, that's also found at 276 Pacific Reports, page 1083. A question from Mark in the chat. How can you get the Attorney General to register you as a sovereign? I have tried everything. Well, actually, I'm not sure that it was the Attorney General that did it. I don't know what state you're in. But what I do is I just send out a registered letter to every chief of police and every county sheriff and every chief judge and anybody that might. I think he's in England. Okay. Well, so then again, it's the same thing. It's still you send out a registered letter to the chief of police. You got chiefs of police there. You got counties. I know England has counties. So send it out to the county sheriff. Send it out to the county attorney. Send it out to the city attorney. Send it out, find out who the prosecutor is. Send them out a letter. You got to use registered mail. And my letter, you're welcome to contact me by email, and I'll send you the one I send. But really, a lot of the arguments can easily be converted over to Magna Carta and stuff like that. Most of these arguments come from the Magna Carta. And so even though a lot of times the U.S. Supreme Court case, it still explains the principle of law very well. And so you got to notice actually, I don't think the Attorney General would do it. I think it would probably be a judge of some sort, like a chief judge in some court would probably do it, because it says he's in Wales. Well, that's okay. Wales is a state. Okay, Wales is a state, just like England is a state. So again, I know you got county judges, and I know you got cities, chiefs of police. I know you got county sheriffs. Again, you serve it on, and let's face it, you could wind up serving on a lot of people. I've sent out hundreds of these things, and so you make a budget. You say, well, I can send out 10 of these a month, or you got to use registered mail. You want proof of service. Registered mail is kept under lock and key, and there's a chain of custody. So you want absolute proof of service. And so what I would do is make a budget and then decide how many you're going to send out how often, and then make a priority who you want to send first, and decide. You want to start with the people that you think are going to be attacking you the first, and so you start out with if you're having problems with the city, well then the city prosecutor and the chief of police, the people that are going to enforce whatever it is they're going to try and do to you. Those are the ones that you want to communicate to and tell them you have no more authority over me than a Walmart rent-a-cop. And you have the oath of office to me, and the Queen has the oath of office to me. I don't owe you any allegiance. I don't owe the Queen any allegiance. She owes me allegiance. And you just start getting up in their face. And the more, I'll tell you, the more you get up in their face, the more they dive for cover. It's amazing how that works. But anyways, yeah, that's what I would do, is just start noticing them. And what happens is at some point they'll put you down as sovereign in their system because you're taking away their presumptions, and usually it's the judges that recognize this stuff. So that's why I would think there'd be a judge that would do it, because they're basically you're putting them in a position that you could sue their butt off, and they'll turn you into a millionaire because violating your rights, because they don't have any plausible deniability, they don't have any qualified immunity, they don't have any of that stuff anymore, and you got them right where it counts. But that's what I would do, and so I wouldn't worry about the Attorney General. I just start serving start serving your public servants, any of them that you think might attack you for any reason. And that's where I would start. Like in the area where I'm at, like I live right now, I'm living in Delaware, and I travel to Annapolis every weekend, which is in Maryland, and so I travel through a couple counties. I go there because there's a place where I go and work out, and there's a Whole Foods place where I buy organic food and stuff like that. It's about 100 miles, and so I drive through a couple counties. And so I'll send a notice to each county sheriff, and I'll find out who the chief judge in the county is, and I'll send a notice to him, and I'll send a notice to the county prosecutor, and then in Annapolis, I'll find out who the chief of police is, and I'll find out who the chief judge is in the municipal court, and I'll find out who the chief prosecutor is and that's doing the prosecuting, and all of that stuff is available online on the internet. Quite frankly, rarely is it not available online or on the internet. But if it's not available, there's a phone number. I guarantee you, there's a phone number, and you can call them up. You just call up the court. You say, yes, who's the prosecutor down there? Who handles the prosecutions? And because I want to send them a letter. That's all. You just say, I want to send them a letter. And you find out so his mailing address would be this. Okay, thank you very much. Have a great day. And be real nice, I mean, you get all sorts of information out of them. They'll be more than happy to help you. Anyways, quote, state citizenship is a vested substantial property right, and the state has no power to divest or impair these rights, unquote. And that's Fabot versus Kingsbury, 1929. I think I already read this one. I know I did. Ignorance of the law is no excuse. Anytime you get anything from the government, it is an implied contract and brings you into their jurisdiction. I don't care what it is. If they send you a letter saying your grass is too long, and if you don't mow it, we're going to fine you $200, that's an offer of contract. Reject their offer of contract. But if they're sending you letters like that, then you haven't done your homework. Because really, if you think about it, if you do your homework, they're not going to want to talk to you. They're going to see you, and they're going to turn and run the other direction. And, there's times when I'll be, like I drive to work, and I usually drive to work at certain hours of the day, and the first few times I drive to work, I might see cops out there, but then after that, I won't see any cops. And I really think that they find out that I'm on the road during those times, and they just tell their cops to go somewhere else, not be on that road. I really think so, because I rarely see cops. And if I do, they're busy. Anyways, quote, all statutes are written very carefully. It's not a quote, but all statutes are written very carefully, and most do not apply to members of the sovereignty. Matter of fact, none of them do. 99% of the time, the government is technically correct. They have lawyers that lay awake at night with this stuff. It's not up to the government to tell you that you're a member of the sovereignty. The government lawyers make up a statute that properly applies to those entities that they have jurisdiction over. The burden is on us to tell them. The burden is on the sovereigns to know and understand the law and to assert their sovereignty. In order to regain your sovereignty, if you lose it, you have to assert it. All you have to do is say the words. The presentation on asserting sovereignty covers a procedure that I have developed. In order to be a true sovereign, you must be self-reliant. You cannot talk the talk. You cannot only talk the talk. You have to walk the walk. You have to be the king. You know, there's nothing that jerks my chain more than some bureaucrat that thinks he's going to make a legal determination for me. And because that's exactly what they do. Think about it. If like, for example, you're driving down the road and some cop turns on his cherries to stop you. Well, he just made a legal determination for you. Think about it. That's exactly what he did. He said, oh, there's a person I can stop. He accused me of being a person, first of all, right off the bat. Perjured his oath of office. Okay? And that's why I serve him with my documents. Because now I got his chief fired. I guarantee you his chief is gone. And his career, this particular cop, his career is ruined. Okay? He will never get another promotion. And he'll be lucky if he's doing some digging ditches somewhere. And again, and that's what I tell them. If you're going to violate my rights, you need to be prepared to go all the way and take me over there and blow my brains out, because by the time I'm done with you, you're going to wish you did, and I'll do it all within the law. And that's why they don't want to talk to me. I don't understand. But I kind of like it, I got to say. And so again, do you know who you are? What happens? What happens with the king? Okay? The king says, off with his head. That's what happens. The king says, off with his head. And then what happens? Off with his head. That's what happens. There's no discussion. There's no debate. It's done. It's all about slavery. It's not about race. It's about slavery. A U.S. citizen or a citizen of Canada or a citizen of Australia is a slave, or a citizen of United Kingdom or a citizen of England. Okay? There's an England citizen and a citizen of England. Okay? Actually, a citizen of, I suppose in England it's a little different. It's probably a UK citizen. A UK citizen will be a slave. It'll be the England citizen that's the sovereign. Okay, yeah, let's go ahead. Hello, everybody out there in Radio Land. This is Glenn Winningham, House of Fern. You're listening to You Know Who You Are, and you're listening to the These Changing Times radio station, and we're talking about common law. We're moving through it. We're going to get it all done here today, it looks like, and we'll probably start on something else. But I have a website. You can find my website at www.sovereigntyinternational.info, and I've got also available videos and stuff. I do private information shares, so there's some videos of some private information shares that I have available, and you can contact me, or there's a link on the website as well. There is, I've also got some groups. We were just talking about a letter from an Arizona senator by the name of Wayne Stump. Well, that one is uploaded to my group at These Changing Times radio website. If you click on the groups link, you'll look for the sovereigntyinternational.info group, and the letter from Arizona Senator Wayne Stump is there. And I've also got a group, a couple groups, private groups at Yahoo and at Google. They're both called Administrating Your Public Servants. Those are separate words. You can go there and search for them. You have to request to join, but usually it's not a problem. And I've uploaded a bunch of files, including this letter from Arizona Senator Wayne Stump, and other files. And instructions on what to do. I also send out my latest notices that I send out, and they're available on these groups as well. And I'm available. I check the emails all the time, and so I'm available as well. But the only thing is that I request is that you do some homework before you start asking a lot of questions, because you know I've answered a lot of questions. And I get tired of answering the same questions all the time. And so there's some instructions when you join the group, especially the Yahoo group. There's some instructions that I ask you to follow before you start asking a lot of questions. There's some homework assignments to do, and then once you're done that stuff and you're starting to get your arms around what exactly we're talking about, then I'll be happy to entertain any questions. I'm available to do private information shares for those that are interested, and you can contact me privately. My email address is engineerwin@gmail.com. And we can talk about that there as well. Okay, so we're just wrapping up this common law presentation, so all of this stuff is about slavery. It's not about race, it's about slavery. A U.S. citizen or a citizen of Canada or a citizen of Australia or a UK citizen is a slave. And they're a subject, actually, is what they are, but a subject is just another word for a slave. And the sovereigns are the state citizens. In other words, an England citizen or a Wales citizen of Wales. Those people are matter of fact, I don't like to say citizen of Wales. I'd say Welsh citizen or England citizen, English citizen, and those are the sovereignty. And either you're the king or you're a subject or a slave. A subject is just another word for a slave. And there's nothing in between. If you participate in their color of law statutes, then you've agreed to be their slave. It is only involuntary servitude that is not lawful. Okay, involuntary servitude is where they're forcing you to be a slave. If they get you in a contract, then they're essentially doing that anyways, but they view it to be a contract. So, we have to recognize that where these contracts are and quit participating. So what do sovereigns do? Okay, well, first of all, sovereigns don't register their births. Sovereigns don't get permission for marriages. Sovereigns don't register their deaths. Sovereigns, all of that stuff, it's recorded. Why did they do it at common law? It was all recorded in the family Bible. And so then what I would do is if I got married, I would record it in the family Bible. And then what I would do, actually what I would do is I would make up a nice certificate and have some witnesses sign a book or a list, and I would probably make a book, have a guest list, a book, and have them sign the book, and then I would make up a nice certificate, and if we could find a preacher that would do it without a marriage license, then that'd be good. But if not, I don't care. We'll make up our own vows, and then we'll say our vows to each other, and then we'll have lots of friends sign as witnesses, and then what I'll do is I'll make certified copies of all of that stuff and get a notary to certify all the copies, and then I'll put it together in a nice package of paperwork and record it with a counter recorder with an affidavit saying this is what happened. I mean, that'd be perfect. And now it's recorded into the public, and they cannot deny it. So because what happens when you record it into the public is that all courts have to give judicial notice to government documents, and once it's recorded into the public, it becomes a government document. It's very powerful. Plus, it becomes public policy, which is like a regulation. All regulations are public policy. Anyways, so it's simple little things that you do that is not following their rules. It's following my rules or your rules, and it's common law, and that way you can make it so that you can get along and have a piece of paper to show them. Say, well, this is what I did, and at common law, I have every right to do that, so. Another thing is the only way our children will be truly sovereign is if number one, if their births are not registered. Number two, they need to be taught the importance of being sovereign. And number three, they need to be taught how to operate as a sovereign. In other words, you've got to help them to get along. So part of it's setting an example, but part of it is just to show them how to do it. You know, how to open a bank account without a social security number or a social insurance number, depending on where you're at. You know, and that kind of stuff. Help them to open up a bank account, because it doesn't do any good to be sovereign if your kids aren't sovereign, because they're stuck being a slave. It's very important, in my opinion, to pass it on. The whole idea of this doing it is so that your kids have something a little better than you have. Quote, if a nation expects to be ignorant and free in a state of civilization, it expects what never was and never will be. And that's a quote from Thomas Jefferson. Nobody said it would be easy, but it is possible. We've been talking about common law, so we've been talking about a lot of common law principles, some of them good, some of them not so good, but that's what common law is all about. And so we have to understand what the law is and how it works in order so that we can deal with it. And if we don't, then we're going to have crooks that are taking advantage of us and abusing us. And what's the alternative? The alternative is to be a slave. And so that's the end of the common law presentation. The next presentation, I think, let's go take a look at my directory here. The next presentation is land titles. We'll do one on land titles. I don't think we'll get through it today, but we'll get started on it. So we're going to talk a little bit about land titles. We're all products of the government's educational system. And the government has taught us what we need to know to operate in their system, but have they taught us everything? They are government schools. They teach us about all sorts of things, but there's a lot of things they haven't taught us, and the burden's on us to go out and learn. And it's out there. It's available. A lot of it we have to use a little bit of gray matter, and some of it like with myself when we go through my presentation on asserting sovereignty, I kind of I've dealt with law and regulation all my life, but so sometimes you just have to take a risk and try something and take the plunge, I guess you might say. And I've made my mistakes. I've done a lot of things, But the thing is I guess what I'm trying to say is that it was because of all of that that I learned a lot. I mean, I learned a huge amount when I've gotten into my battles, and when I first was really starting to do this stuff, when I developed this procedure, is when I was under attack, and it was like a feeding frenzy. They were coming at me from every direction you can't possibly imagine. But once you do some certain basic little things, you start protecting yourself. In other words, first of all, you never have a bank account with a social insurance number or a social security number. Second of all, you never, ever, ever tell them where you're living, okay? You always use a private mailbox and different things like that help protect you, so that that way it gives you a lot of flexibility to make mistakes and administrate your public servants to the point that they don't want to talk to you, even though you did make the mistakes. And a good example is that when all of this stuff was going on, there was a warrant issued for my straw man, and I think that warrant is still out there today. But the bottom line is they didn't know where to find me. They actually did find me at my work, and that's when I filed a lawsuit against them. And after that, they didn't want to talk to me anymore. And so I guess what my point is that because they because of the fact that they didn't know where to find me, they had to find me at my work, and so then I just took a week's vacation and filed this lawsuit, and by the time I got that lawsuit filed, then I sent a notice. I sued the chief judge of the Supreme Court, and I told her to quash the warrant. Well, once I filed the lawsuit, then I sent the chief judge a notice, and I said, I named you in this lawsuit, and I hereby demand that you quash this warrant for this arrest of the strawman vessel. And I said, quote, because we all know that corporate commercial agents, the police in brackets, are too stupid to tell the difference between a sovereign living soul and a strawman vessel. And then I said, furthermore, if you don't quash the warrant for the arrest of the strawman vessel, it will be further proof of your dereliction of duty to regulate your subordinates. And then I said, and by the way, I filed this lawsuit against you, and this is the case number, and you're going to get served with it soon enough. But if you fail to quash the warrant for the arrest of the strawman vessel, it will be further proof of your dereliction duty to regulate your subordinates. Now, and the significance of that is that when there's a conspiracy, in order to allege a conspiracy, you have to show an act in furtherance of the conspiracy. And so I had been serving her with documents about these criminals that ultimately resulted in this warrant. And so now I filed a lawsuit against the criminals and her, and now I'm telling her, you either better quash this warrant or we're going to have basically my act in furtherance of the conspiracy. And so she quashed the warrant. Actually, what I think she did is she issued a restraining order, and basically she told them to leave me alone, to only arrest the straw man. And, of course, the straw man doesn't exist. And so then they left me alone. And then, you know, a lot of that stuff came out in the lawsuit. But ultimately, the lawsuit got dismissed. But so the point being is that some basic things is because of the fact that I didn't have a Social Security number assigned to associated with the bank account, and because of the fact that I was attacking them as much as they were attacking me, I had thousands of dollars in the bank account, and they never touched them, and they couldn't find me except at my work. And when I filed the lawsuit, well, they didn't want to find me there. You know, again, you got to go on the attack. The best defense is a good offense, and I just can't say that enough. Anyways, so let's get moving here. Quote, the right to own and manage property is a natural, unalienable right, unquote. Okay, remember we were talking about in common law, we're talking about natural rights, okay? Well, that's what this case is saying. The right to own and manage property is a natural, unalienable right, okay? That's found at 73 Corpus Juris Secundum, Section 13, page 181. Quote, perfect ownership is the right to use and dispose of one's own property in the most unlimited manner, and nothing prevents an owner from dismembering his property and from disposing of each separate dismemberment as he pleases, unquote. and that's Amerada Petroleum Corporation versus Reese, 196 Southern Reports, page 558, and that's also found at 195 Louisiana Reports, page 350. And so with land, if you don't, if first of all, these counties say, well, you can't subdivide your land if the parcel is down less than 5 acres or something like that. Well, if they're telling you anything about your land, then you don't own it. Okay, that's the bottom line. If they're telling you what to do or how to do it, zoning regulations, any kind of rules and regulations on your land, then you don't own it. And if you're paying an annual rent, okay, property taxes, okay, if you're paying an annual rent, then you don't own it, okay? And that's not perfect ownership. Perfect ownership is the right to use and dispose of your property in the most unlimited manner, okay? And they cannot limit it in any way. If they are, you don't own it. That's the bottom line. There's this is taken from Black's Law Dictionary, 6th edition. An absolute estate is a common law classification. An absolute estate is a full and complete estate or an estate in lands not subject to be defeated upon any condition. An allodial or free. Allodial means free or not holden of any lord or superior, owned without obligation of vassalage or fealty, the opposite of feudal. Allodium is land held absolutely in one's own right and not of any lord or superior, land not subject to feudal duties or burdens, an estate held by an absolute ownership without recognizing any superior to whom any duty is on account thereof. Okay, moving along here. Allodium estate signifies an absolute estate of inheritance in contradistinction to a feud. And this is taken from Bouvier's Law Dictionary, 1856 edition. So an allodium estate is in contradistinction to a feud, as in feudal. Now, all of the titles that I've seen in America are all feudal because they're making people pay an annual rent in the form of property taxes. So you don't really own it. And if you don't pay the property taxes, they do what's known as an unlawful detainder action, which is an action to remove tenants. If you register your land, you're essentially giving your land to them, like in land titles in Canada as registered, but you can record your land, and that is not a gift, and we need to train our government bureaucrats, especially in Canada. But they're not as dumb as they let on, I'll tell you. There's some of them, because I've heard of people in Canada where land titles would tell them that they don't have jurisdiction over their land, and that means that they have absolute title. If land titles doesn't have jurisdiction, then you have absolute title. Real property is that which consists of land and all rights and profits arising from and annexed to land of a permanent, immovable nature. In order to make one's interest in land real estate, it must be an interest not less for the party's life, because the term of years, even 1,000 years, perpetually renewable, is a mere personal estate. And that's taken from Bouvier's Law Dictionary, 1856 edition. So real estate is not a real ownership in land, okay? Real property is real ownership. Real property is land and everything that's attached to the land. Real estate is real property that you have an interest in, but you do not own it. Estate is the operative word. An estate is something you have an interest in but do not own, like your father's estate. This is taken from Bouvier's Law Dictionary, 1856 edition. Title estates. A title is defined by Lord Coke to be a means whereby the owner of lands hath just possession of his property, and that's taken from Coke's Littleton, page 345. It's also found in Blackstone's Commentaries, book 2, page 195. And this is the definition of title to lands only, okay? So there's definition number 3, as we're only covering some of these definitions, okay, in Bouvier's Law Dictionary, 1856 edition, but definition number 3 is a title is either good, marketable, doubtful, or bad. Okay, there's only 4 kinds of title: good title, marketable title, doubtful title, or bad title. definition number 5, a marketable title is one which court of equity considers to be so clear that it will enforce its acceptance by a purchaser, unquote. Now, remember, a marketable title is a title that the banks loan money on, okay? That's what the banks, when they loan money on title, it's a marketable title. So a court of equity, there's 2 kinds of title in land, okay? There's a legal title and equitable title. Now, and the reason the difference is that, for example, if you have a mortgage on your house, okay? If you have a mortgage on your house, you have legal title to the house, but the bank has equitable title. And everybody knows what happens if you don't make payments on that mortgage. The bank is going to take you to court, and the court is going to give them legal title too. And that's what happens when they foreclose. So that's what a court of equity is. Okay, remember, is that we talked about that where there's no common law remedy. See, at common law, a mortgage is full of fraud. So a mortgage means absolutely nothing at common law. And so a court of equity, but a court of equity, especially because the government is bankrupt, and the bankster thieves are the ones that own and operate the government now. So therefore, a court of equity will do whatever the bankster thieves want to do. And so you'll lose your house. Definition number 7. The doctrine of marketable titles is purely equitable and of modern origin. At law, every title not bad is marketable, and there's some citations after that. But so the doctrine of marketable titles is purely equitable and of modern origin. Okay, so equitable as in court of equity. And modern origin, okay, as in, because the banks are thieves. But I don't know how old that is. Of course, this is Bouvier's Law Dictionary, 1856 edition, so it can't be that modern. Anyways, definition number 9, at common law, doubtful titles are unknown. Every title must be either good or bad, okay? So at common law, there's no such thing as a doubtful title. Either the title is good or it's bad. Title estates, definition number 10, is a bad title is one which conveys no property to a purchaser of an estate. In other words, it's basically it gives you nothing. You bought nothing. Definition number 11 is title to real estate is acquired by 2 methods, namely descent and by purchase. And so the significance of that is that there's people I know in Arizona that have passed their land on father to son through generations, and they've never paid property taxes, and the county tax assessor or nobody is interested in communicating with them because again, they just pass it on in the family from generation to generation. So they have they have a land patent, and they've never clouded that patent by doing a deed, okay? Because what that does is it actually clouds the patent. Once you have a patent, that's the best kind of title you can get. What happens is that if you sell your land, what happens is that with Federal Reserve notes, okay, when you buy land, if you pay Federal Reserve notes for it, what happens is that Federal Reserve notes are not money. They're IOUs. That's all they are. So if I spend Federal Reserve notes and buy something from you, I'm essentially saying that some guy promised to pay me, and when he pays me, I'll pay you. So that house is not paid for. If I buy something from you with Federal Reserve notes, it's not paid for. And what that does is it creates what's known as a type of a trust called a usufruct, U-S-U-F-R-U-C-T. We're going to cover that more later. I'm not sure if we'll get to it today because we only got about 15 minutes left in this presentation today. But But so the point, though, is that it creates a usufruct. If you use, I'll use, okay, as in Bank of England notes or Bank of Canada notes or Federal Reserve notes, those are not money, okay? Those are IOUs, okay? Think about it. The reason they're called an IOU, first of all, they're evidence of the debt of Federal Reserve notes are evidence of the debt of the United States. Bank of Canada notes are evidence of the debt of Canada. Bank of England notes are evidence of the debt of England or United Kingdom. And so the point is that when you use those things to buy something with them, it's not paid for, okay? And so therefore it creates a usufruct. And usufruct is the right to use something without owning it. And that's why they're charging you a yearly rent. And now it's to the point that because there's so many people that are using them, and the courts presume that you used Bank of England notes or Bank of Canada notes. And so what happens is that what you have to do is put it on the face of the deed. I buy it with gold or silver coin. And actually, I don't purchase it. What I do is I call it, I converted a gold or silver coin to land. And I've seen court cases that talk about it that way. So that's what I do. And it's very powerful because conversion is common law. So there's different kinds of color of title. Okay, remember we talked about color of law? Well, there's such a thing as color of title. And we're going to talk about that. And so think about it. If it's color of law and it's a fraud, then color of title is the same thing. So anyways, land titles come in various forms. There's a general warranty deed, special warranty deed, sheriff's deed, judicial deed, quitclaim deed, and a land patent. A general warranty deed is a deed where the seller wants the title to be free and clear of all liens and encumbrances. A general warranty deed is what is generally received in order to get a mortgage before the bank will authorize the mortgage, and a general warranty deed is considered marketable title. A special warranty deed is where the seller will want the land to be free and clear of all liens and encumbrances with some reservations. A special warranty deed is usually used when the land of the subject, or the land is the subject of a foreclosure or a tax sale. And that's why they do a special warranty deed, because there's a cloud on the title. So they're giving you a warranty with some reservations. Special warranty deed is also considered marketable title. A sheriff's deed is when the sheriff sells a piece of property or real estate or real property. It could be from a foreclosure or tax sale or something like that. Sheriff's deed is also considered marketable title. A judicial deed is when a judge sells real property, and a judicial deed is considered marketable title. A quitclaim deed. A quitclaim deed is kind of interesting because and we're going to talk about some court cases that talk about this too. But a quitclaim deed sells your interest in the property. I don't know if anybody's heard of the Brooklyn Bridge being sold, but it has. The Brooklyn Bridge has been sold on numerous occasions. And the Brooklyn Bridge, by the way, is owned by the state of New York. And so the state of New York didn't sell it. But so what that means, though, is that what they did is they use a quitclaim deed. And a quitclaim deed essentially says, I sell you my interest in this property, okay? I may not have an interest, but what interest I have, I sell you. So it can be a bit of a scam. But a quitclaim deed can also sell land just as well as anybody else. In other words, a lot of times, like these people in Arizona I was telling you that passed it on from generation to generation in the family. Well, that's probably how they did it. Okay, I don't know for sure, but I know a lot of farmers do sell their land to their sons with a quitclaim deed. And what they do is they just give their son a quitclaim deed to the land. And think about it. After 7 years, the son lives on the land for 7 years. He's got squatter's rights anyway, so he doesn't even have to have a quitclaim deed. He's been living there for more than 7 years. And so that's essentially what it does. Is it gives him the right to live on the land for 7 years without any complaints by the father, and after that, he owns it anyways because he's been squatting on it. A property sold because of a tax sale can be transferred by a quitclaim deed. A quitclaim deed can transfer title as effectively as a general warranty deed, and it may transfer nothing, okay, as in the Brooklyn Bridge. A quitclaim deed, quote, is a deed of conveyance operating by way of release that is intended to pass any title, interest, or claim which the grantor may have in the premises, unquote. That's taken from Black's Law Dictionary, 6th edition. Now, the thing to understand is that, like tax sales and stuff, are often are quitclaim deeds. Now, you have to understand, from our presentation on color of law, all taxes are color of law, and so they don't have any authority to tax anything. And so, if they're color of law, then they clearly wouldn't have any authority. And so, if whoever buys the property, if the seller really knows the law, well, the tax means nothing. And so then they had no authority to sell it. And so therefore, whoever bought this quitclaim deed from the county assessor really bought nothing. It comes down to whether the guy that owns the property knows the law or not, and that's why I would never buy a tax sale or a foreclosure, because they're all color of law, and you might wind up with nothing. Color. Okay, we're going to color of title now. Okay, well, this is color means an appearance, a semblance, or smulcrum as distinguished from that which is real, a prima facie or apparent right, hence a deceptive appearance, a plausible assumed exterior, concealing a lack of reality, a disguise or a pretext. And that's taken from Black's Law Dictionary, 5th edition, on page 240. Colorable means that which is in appearance only and not in reality what it purports to be, hence counterfeit, feigned, having the appearance of truth, unquote. And that's Wendell versus Flynn, 196 Oregon Reports, page 654. Color of law means the appearance or substance or semblance without the substance of legal right, misuse of power possessed by virtue of state law, and made possible only because wrongdoer is clothed with authority of state is action taken under color of law, and that's Atkins versus Lanning, and that's found at 415 Federal Supplements, page 186. Color of title. These deeds, quote, these deeds include the ones as follows: warranty deed, quitclaim deed, sheriff's deed, trustee's deed, judicial deed, tax deed, will, or any other instrument that purportedly conveys the title. Each of these documents state that it conveys the ownership to the land. Each of these, however, is actually a color of title, unquote. And that's found at G. Thompson, Title to Real Property, Preparation and Examination of Abstracts, Chapter 3, Section 73, page 93, 1919. And so any of these deeds, they're all color of title, and which means that there is no title. They don't pass on the title. They don't nothing. And it can be, but it may not be. Depends. Isn't that encouraging? Anyways, quote, when we say a person has a color of title, whatever may be the meaning of the phrase, we express the idea, at least, that act has been previously done by which some title, good or bad, to a parcel of land of definite extent has been conveyed to him, unquote. And that's St. Louis versus Gorman, 29 Missouri Reports, page 593, and that's 1860. Quote, there the complainant seems to have relied upon a tax deed as conveying to him the fee. And to sustain such a bill, it was incumbent upon him to show that all the requirements of the law had been complied with, unquote. And that's Hulls versus Bunton, 47th Illinois Reports, page 396, 1865. Now, so let's analyze this one a little bit. It says here, the complainant seems to have relied upon a tax deed as conveying to him the fee, and to sustain such a bill, it was incumbent upon him to show that the requirements of the law have been complied with. Well, what they're essentially saying, it sounds like somebody bought some land, and remember I was telling you that all taxes are color of law, and so somebody bought some land, bought a tax deed, okay, from the county assessor based on a tax, and it sounds like that the owner knew the law, and the owner basically, the guy that bought this tax deed bought nothing, because the owner said that you don't have anything. I own this land. That tax is a fraud, and the court upheld it because they're saying the complainant seems to have relied upon the tax deed as conveying to him the fee. The fee is the tax. And to sustain such a bill, it was incumbent upon him to show that the requirements of the law had been complied with. And so the court sounds like they were ruling against him, and the guy that owned the land still owned the land. And that's the perfect reason why I would never buy tax sales or at least I wouldn't say never, but if I did, it'd have to be a screaming deal to where I would take a chance and you know, buy it, and but I would understand that I might not be buying anything. Okay, moving along. Quote, authorities hold that to render a title marketable, it is not only necessary that it shall be free from reasonable doubt. In other words, that a purchaser is not entitled to demand a title absolutely free from every possible suspicion, unquote. And that's Kleinings versus Dolan, 52 Washington Reports, page 496, 1909. Yes, and that is true. A marketable title is not free of every possible suspicion. A marketable title is just one that is free from reasonable doubt, whatever that is. Okay. Quote, a patent to land issued by the United States under authority of law is the highest evidence of title, something upon which its holder can rely for peace and security in his possession. It is conclusive evidence of title against the United States and all the world, unquote. And that's found at Book 2, American Law of Mining, Section 129 at page 357. And that's also found at Nichols versus Rice-Avey, South Dakota, 1985, 610 Federal Supplements, page 1245. So a patent to land is a pretty good title, but we're going to learn a little bit more. It's actually a call of title too. Nothing but a patent taxes a perfect and consummate title, unquote. And that's Wilcox versus Jackson, 38 U.S. 498, 1839. Quote, a patent issued by the government of the United States is legal and conclusive evidence of title to the land described therein. No equitable interest, however strong, to land described in such a patent can prevail at law against the patent, unquote. And that's Land Patents, Opinions of the United States Attorney General's Office, September 1869. Now, I suppose what we ought to do is wrap things up. We're coming up to the end here, and yeah, we got 2 minutes. So I've got a group. If anybody's interested, there's a group that's on These Changing Times you're listening to. Do you know who you are? This is Glenn Whittingham, House of Fern, and you're on These Changing Times radio website. And I've got a group. It's called sovereigntyinternational.info. It's on These Changing Times radio website, and I've uploaded some files there. I also upload. Once I get this, I'll get this file as a sound file. I will convert it to a video and upload it to YouTube. And when I do that, I will put a link on These Changing Times on sovereigntyinternational.info's group on These Changing Times radio website. And so I would recommend that you check back there if you want to find out. You can also go to YouTube and do a search for my YouTube profile. It's Sovereign Living, and you can find out that I've uploaded about 110 videos up there, and so you can get all that stuff there as well. I've also got a couple private groups. They're called Administrating Your Public Servants at Yahoo and at Google. You can go there and request to join. I'm also available for private information shares. I've got some videos that are available and some DVDs if you don't want to download all the ones from YouTube. And so I've got the DVDs, all the videos on DVD, and you can get them from me privately. There's a link on the sovereigntyinternational.info website for that kind of stuff. You can, anyways, I suppose that's about it. If anybody has any questions, you can email me privately at engineerwin@gmail.com. That's engineerwin@gmail.com. We can kind of go from there. But I suppose what I'll do is I'll turn the time back over to Kat. Thank you very much for giving me the opportunity to talk to everybody, and I hope that you've learned something and that you can use it to your advantage. Next week we'll be talking about land patents, and then we'll finish up this presentation on land patents, or actually on tomorrow. We're going to be on again tomorrow at 4 o'clock 4 o'clock Central Time, and then we'll be on again on Sunday. So I guess I'll turn the time over to Pat or Kat, I should say, and let her take it over.
Thank you, Glenn, and I tell you, Glenn, it's our pleasure to have you here, and I'm sure everybody who's listening will agree with me. So you've been listening to Do You Know Who You Are? With Glenn Winningham, and as he says, he is on again tomorrow at 9 p.m. UK and Ireland, and 3 p.m. CST, which is 4 p.m. Glenn's time. You have been listening to Glenn Winningham on These Changing Times with a Z or a Z, depending on where in the world you come from. These Changing Times Radio.ning.com. Do stay tuned, because Beyond the Looking Glass is coming up at the top of the hour with Rafana 9000. Thank you all for listening, and see you tomorrow.